The Women's Economic Security Act strengthens workplace protection and flexibility for pregnant and lactating employees, expands employment opportunities for workers in high-wage, high-demand occupations, and reduces the gender pay gap by empowering employees to openly discuss their wages if they wish to do so without fear of retaliation. Under WESA, any employee who needs an accommodation related to pregnancy or childbirth are entitled to reasonable accommodations, regardless of the size of their employer. Pregnant employees have the right to certain accommodations without having to provide a doctor's note or any other proof. All parents are eligible for protection under WESA, regardless of their gender. These accommodations include more frequent or longer restroom breaks, food and water breaks, seating, and a limit of lifting more than 20 pounds. Additionally, employers must actively engage with their employees to find other reasonable accommodations that meet their needs. This could include temporary leave of absence or modification in their work schedule or job assignments. It's important to note that employers cannot force pregnant employees to take a leave or accept accommodations if they do not want them. All employers, regardless of size, must provide up to 12 weeks of unpaid pregnancy and parental leave to their employees, unless the employer agrees to a longer leave. This entitlement applies to all employees, regardless of how long they have worked for their employer. When employees take pregnancy or parental leave, they are entitled to return to their former positions or positions with comparable duties, hours, and pay. It's important to note that if an employee takes FMLA leave for reasons unrelated to pregnancy or parental leave, they will still be entitled to 12 weeks of leave for pregnancy-related illness and parental leave in the same year. All parents are eligible for leave time under WESA, regardless of their gender. Employees must begin their 12 weeks of parental leave within 12 months of the birth or adoption of a child. An exception is made if the child must remain in the hospital longer than the mother. In such cases, the leave must begin within 12 months after the child leaves the hospital. Employees can take 12 weeks of leave consecutively, and in limited circumstances, they may be able to take the leave intermittently. While WESA only requires 12 weeks of unpaid pregnancy and parental leave, employers have the option to grant additional unpaid leave. If an employer does provide additional unpaid leave, employees are still entitled to their job after the approved time is completed. All employers, regardless of size, must provide a notice of nursing and pregnant employee rights at the time of hire and when an employee makes an inquiry or requests parental leave. This notice must also include information about the right to receive reasonable pregnancy accommodations and paid breaks to express milk. Employers cannot reduce an employee's compensation for time taken to express milk. While breaks to express milk may run concurrently with existing breaks, including unpaid breaks, employers cannot reduce an employee's pay or require them to make up time used to express milk. Furthermore, the space provided for expressing milk must be clean, private, and a secure space other than a restroom, shielded from view and free from intrusion from coworkers and the public. It must also have access to an electrical outlet. For more information about the Women's Economic Security Act and its provisions, please email dli.laborstandards@state.mn.us or call 651-284-5075 or 800-342-5354. Thank you.